Pathways to Family Green Cards and Citizenship, Navigating the Journey Together. I'm Ann Massey Badmus with Badmus and Associates, and I'd like to thank you for attending our webinar today. We hope to provide some information that will assist you or those you know or your network with immigration matters related to family, green cards, and citizenship. So before we get started, I have a few housekeeping rules and not rules, but housekeeping information to provide to you. First of all, if you do not hear anything, then please put that into the chat so that I can know that you are not hearing, and hopefully we can assist you with that. Otherwise, I'm assuming that everyone is hearing me. So first things first, you can ask questions at any time during the webinar, and the way to do that is to use the Q&A or the question mark little bubble on your screen or on your phone instead of the chat feature. So just use that section, and whenever a question comes to mind, go ahead and type your question in. We will attempt to answer all questions at the end of the webinar. If you do put your question in the chat, I will look there, but probably ask you to move it over to the question answer bubble area so that we can keep track more easily. Regarding questions, we want to maintain confidentiality because this is a public forum. So as with all legal matters, you want to make sure that your personal details are not revealed to those who you do not want to know about them. So please ask your questions in a very general manner without providing personal details. Just a little background about our firm. We are Badmus and Associates, as I mentioned before. So we've helped thousands of clients since 1993 with immigration matters, and have been fortunate to be recognized in several areas, such as best lawyers for Dallas, Texas, in immigration, as well as best lawyers and best law firm in the Dallas area as well. So before we go forward, again, the final thing I just wanted to address was that to emphasize that this is a presentation that is for informational purposes only. Please do not consider this as legal advice because every situation is different, and so you want to be sure that any information that you apply to yourself is correctly applied. And so therefore we suggest that if you want assistance or definite legal advice regarding your own specific case, you should consult with one of our immigration attorneys. So our agenda today, as I mentioned, is to help to go through family immigration, how to help your family members, or if you are one of the family members, how to legally immigrate to the U.S., and then also how to become a U.S. citizen. And we'll definitely have question and answer section at the end. So the first things first, we'll talk about helping family legally immigrate. And I like this image because it is really truly the case that it is a very complicated maze to get through the immigration process, especially for green cards. So as I said, a lot of this is going to be information. Some of it may seem complicated, and you may not be able to recognize how it might apply to you. So that's why we definitely suggest that if you think any of this could apply to you, or you're interested in immigrating or helping someone immigrate through this type of process, please do reach out and at least get some legal advice before proceeding. So who can sponsor family members? So the only people in the U.S. who can sponsor a family member are those who are U.S. citizens, whether they're citizens by birth or naturalized citizens, or those who have lawful permanent residence or the green card themselves. Now, the family members that they can sponsor are different depending on their status. So U.S. citizens can sponsor spouses. So if you are a U.S. citizen, you can sponsor your spouse. And the category that they are considered to be in is what's called immediate relative. And we'll talk about a little bit more why that's relevant into understanding why we want to why you should know how a spouse of a U.S. citizen is categorized. So this is just we don't have a lot of time to go through all the details, so I'm just trying to give you an overview. But typically when a U.S. citizen is applying for their spouse, of course, they have to show that they are legally married either in the United States or in any foreign country. So you do not have to be married in the United States to be recognized as a married couple, but you do have to show that your marriage is considered to be valid in whatever country that you got married in. But the key part of this process is to show that you did not get married solely for the purpose of immigration. So you did not get married because you wanted to get a green card. And the way the government knows that that's the case, that you're marrying for love or some other reason besides getting a green card, is providing proof of what they call a bona fide marriage. So listed here on this slide are some examples of the documents that are typically used in order to prove that you have a bona fide marriage. So it's important that you gather as many of these documents as possible. Make sure that once married, you have established finances together as much as possible, such as bank accounts, insurance coverage, of course, filing your taxes, preferably as married, or if not, then indicating that you are married. But if there's a tax advantage to filing a tax a different way, you still want to show that you are married. If you have children together, of course, birth certificates, and then notarized letters, or what we call affidavits from friends and family. Now, for some people who are actually not together because maybe the immigrant spouse is still in another country, and they're applying to actually bring that spouse here through the green card process or immigrant visa process, you may not have a lot of this information, but it's still possible to get approved, at least initially, if you provide as much as possible that you have. So things like if you have children together, that might be another, that would be one evidence. If not, you can use things like affidavits, as I mentioned, from friends and family, your wedding pictures. So if you're not able to jointly combine your finances at that point because of that separation, or then it's still possible, but you would have to use other evidence. Another immediate relative category is parents. So U.S. citizens and only U.S. citizens can sponsor their parents, but that U.S. citizen must be age 21 or older to sponsor. So proof, the process or the proof needed for U.S. citizens sponsoring their parents would be, of course, the birth certificate of the U.S. citizen themselves, showing their parents' names. If their birth certificate was not registered at the time of birth, but registered later, then you may need to have what's called secondary evidence, which is things like a hospital record, religious record, school record, or affidavits to verify the information in the birth certificate itself. If the father is the sponsored relative, then a marriage certificate between the parents is required, or if the parents were not married, then the father must prove that he supported the U.S. citizen before that U.S. citizen was age 18. So that kind of proof would be things like payment for school, payment for health care, being child support, things like that. But you must prove that's the case if the parents were not married. And then finally, sometimes a DNA test is required if the government does not feel that the records provided, like the birth certificate or the secondary evidence, is enough. Then on occasion we have seen them request or allow a DNA test as an alternative, so to definitely prove the relationship between the parent and the U.S. citizen child. Another category of immediate relative for U.S. citizens are children under the age of 21 and unmarried. So what that means is if you're a U.S. citizen and you have a child who is not a permanent resident under the age of 21 and they're unmarried, then you can apply for them and they are an immediate relative, which is a faster track than some other categories that we'll talk about later. So essentially, you can be a in addition to the natural born children of a U.S. citizen, a stepchild can also be sponsored by a U.S. citizen if the parents, the U.S. citizen and the natural parent of that child were married before the child was age 18. And then for adopted children, they must be under the age of 16 when adopted, and in order, and in some cases have been in the custody of the U.S. citizen for at least 2 years before they're eligible for sponsorship. There are some other conditions as well, especially for those who are orphan children, but it's a very special type of process that we don't have time to discuss today. Next, I'm just going to talk briefly about the fiancé visa. So the fiancé visa has seemed to gain popularity in the past 5 years or so, and essentially it is an immediate relative petition. Only U.S. citizens are allowed to apply for the fiancé visa for their immigrant fiancé. So the K visa allows a U.S. citizen to bring their foreign-born fiancé to the United States with the intention of getting married. If you're already married outside the United States, then this would not apply. You cannot use the fiancé visa, and you have to go through the immigrant visa green card process. And the other fact is that the fiancé must be outside of the United States, not in the United States, where they may be temporarily in the United States, but they cannot be permanently residing in the United States or have some other permanent visa like an H-1B, not permanent visa, but another temporary visa like an H-1B or something where they are resident. They must be resident outside the United States in order to qualify as a fiancé. And that would make sense because it doesn't really help if someone is already in the US, then usually they can just apply immediately after marriage. So both partners must be legally free to marry. So you have to show that if you have any prior marriages, you have to provide proof of divorce or death certificates if you're widowed. So that's definitely a requirement to prove that you're legally free to marry. And key to that also is that you have to prove that you have met the fiancé within the past 2 years, physically met them, have either usually gone to their country and have pictures of you together, have maybe statements from other people, notarized statements showing that they know that you have been together in that country, travel tickets tickets to travel to those countries. You have to show that before you apply within the past 2 years, you have actually met each other. And it's not just all been correspondence and an agreement to marry. After the fiancé visa is issued, then the spouse, or the not spouse, but the fiancé can immigrate, come to the U.S. and within 90 days get married. And once married, then they actually apply for the green card itself to become a permanent resident. So I've been talking quite a bit, or mentioning quite a bit, immediate relative, and that term is key because an immediate relative is a category that means that there is no limit on the number of people who can immigrate to the United States from any country at any time if they are an immediate relative. So there's no waiting list. It's a matter of processing time, not a matter of being on hold until there's an immigrant visa available. So immediate relatives who came, another advantage to being an immediate relative is that if you came into the United States with a valid visa, such as a visitor visa, for example, and even if you overstayed that visa or no longer have valid legal status in the United States, but you're still in the United States, you can still apply for the green card through marriage to a U.S. citizen, or being a parent of a U.S. citizen, or being a child under the age of 21 of a U.S. citizen. So if you're in that immediate relative category, then you are able, despite your current legal status, whether it's legally here or not legally here, but you did enter legally, you can still get a green card without having to leave the United States. However, as we'll talk about a little bit more, If you did not come in legally into the United States, say for example, you crossed any of the border, the southern or the northern border of the United States, and you have what we call enter without inspection, meaning that you did not have any permission to come into the United States, then you are not, even if you are married to a U.S. citizen and you are an immediate relative, you cannot uh, uh, complete your green card process in the United States. You will by law have to leave the U.S. and apply at the U.S. embassy, and that comes with uh, some restrictions as well, and so it's not really a great option. But it may be some options that you could look at otherwise. So um, going from immediate relative, I want to talk about the family preference categories, and all that means is that um, these categories are those that have a limited number of green cards available each year. So unlike the immediate relatives, we have to look at, a permanent resident or a U.S. citizen can apply for these categories, but their relatives are going to be put on a wait list, which for some can be 20, 30 years. So it's not the ideal area, or not the ideal type of process, but unfortunately it could be the only process that many people could use, and unfortunately they would have to be on that waiting list. So we'll talk and show you a little bit more about how that works as far as the waiting list, or what I call the waiting list for these categories. So there are 4 family-based categories outside of the immediate relative category. So we have FB1, which is for unmarried children, sons and daughters of U.S. citizens. So when I say sons and daughters, we kind of distinguish that from an unmarried child. But the immigration defines a child as someone under the age of 21. So if your child is not under the age of 21, they're over the age, they're 21 or older, and you had not applied for them, then you as a U.S. citizen can apply for them, but they're going to be placed in this category as opposed to immediate relative category. So they'll be in the FB1 category because they're age 21 and older. The FB2 category is for spouses and children of permanent residents. So LPR means lawful permanent resident. And so if the for spouse category and children under the age of 21, that is the FB2A category, as I have shown on the slide. And then the FB2B category are for, children age 21 and older, unmarried children age 21 and older of a permanent resident. FB3 is for married sons and daughters, married children over the age of 21 of U.S. citizens. And that's very important because if you apply for a child or a son or daughter under the FB1 category when they're unmarried, and then they become married, then they will be moved to the FB3 category, which is, as we'll see, a much longer waiting period than the FB1 category. So it's important to understand that. And then finally, the FB4 category is the category for brothers and sisters of U.S. citizens. So again, only U.S. citizens can apply for brothers and sisters. And so you establish the eligibility for that, and then we look at how long it will take for them to immigrate. So just a little more background, as I mentioned, sons or daughter must be unmarried at the time your application until at the time the petition is filed. And by the way, the petition is by the U.S. citizen. So the U.S. citizen files a petition called an I-130 petition. And then once that petition is filed, then the application process gets started. In the FB1 category, you must be mindful again that the son or daughter must be unmarried at the time filed until their green card is actually granted. So they have to stay unmarried if they're going to be in this category. If you had applied for, if you are a U.S. citizen, you had applied for a child who was under the age of 21, but the petition was not approved, and they had already reached the age of 21, then it could be the application would be moved over to this FB1 category, unless you are in a certain stage of the process where perhaps an I-485, which is the second part of the green card application, was filed before age 21. So there's some caveats to this, but I just want you to know that this could happen when there is an approved FB1 petition and the son or daughter marries. As I mentioned before, the petition is automatically moved over to the FB3 category. Okay, that's kind of what I want to mention about that one. So why is this important in terms of those categories? As I mentioned before, there is a limited number of green cards issued every year, very limited number, and it really what it means is that there is a limited number of immigrant visas available. So an immigrant visa is equivalent or the same term, means the same thing as a green card. So the next step to getting a green card, once the I-130 is filed and approved, depends upon whether an immigrant visa is available. And what's key that everyone should understand when they do file an I-130, the date that you file the I-130 petition is what's called the priority date. And that date is critical to determining when your family member can actually immigrate to the US. So you want to definitely know what your priority date is when you file an application and when you get the approval. It will be noted on the approval notice. So note that and then compare that date to what we call the visa bulletin. So the visa bulletin is issued every month by the Department of State, which is the agency that covers all of the US embassies throughout the world. And it's used to determine whether an immigrant visa is available for any particular applicant. So this is the visa bulletin for September coming up 2024. And I just want to briefly go over that so you can see how it is laid out. So on the far left column, it's a family sponsored categories. So F1, F2A, F2B, F3, and F4, which I went over. So not only is your eligibility based on the priority date and your family sponsored category, it's also determined by you as the immigrant's country of birth. So if you are born in any of the countries that you see here that are specifically laid out or are specifically defined as China, India, Mexico, or Philippines, then you would need to look in those columns to see the cutoff date. If you are not born in any of those countries, then you just look in that first column, all chargeability areas, which pretty much is all countries besides those 4 countries. So you would look there for your cutoff date. So the cutoff date is the date listed on the visa bulletin, and you would compare your priority date to the cutoff date. So let's say, for example, if you are under the F4 category as a brother or sister of a US citizen, and you are from UK, for example, then your cutoff date, the cutoff date is August 1st, 2007. So that means only those people whose I-130 petition was submitted on their behalf before August 1st, 2007 are now able to finally immigrate to the United States. So you can see it's a very long time, but it's actually even better than some other categories or other countries. For example, the Philippines is February 2004, Mexico, February 2001. So it's unfortunately a very long process depending on the category. So some facts to know about the visa bulletin and tracking your relatives' eligibility to get an immigrant visa or timing to get an immigrant visa. As I mentioned, the priority date on the I-130 petition must be before the cutoff date on the visa bulletin. In addition, you're going to look at the country of chargeability, which is the place of birth, and look at the categories, but also know that it's very unpredictable. So even though we might see some progress in those dates, the dates can always go backwards, or the dates could just stay there. The cutoff dates could just remain for months and months and months, even years. So it may not, even though it may look like, okay, every month the visa bulletin is issued, those dates may still not change every month. So don't expect that they would move forward very quickly. It just really depends on the number of applications that are pending, that have been approved every year. And they use that number against the number of visas available. I will say to let you know that the immigrant visa available, the number of immigrant visas issued each year is about 140,000, and they're divided up between employment related and family related applications. So if you should know that in October is when the government issue or has new immigrant visas available. So the government fiscal year is October to the end of September. And so we're coming up on September. So in October, the visa bulletin hopefully should have some improvement because there will be new numbers or new visas available at that time. But it doesn't always happen that way because it just depends on the backlog that's going on. There may be tons of applications still waiting to be approved and decided. So how to apply for family? As I mentioned, the first step is the I-130 petition that's filed by either the U.S. citizen or the permanent resident. Then, depending on the eligibility or where the immigrant is or the family member is located, if they are eligible, like an immediate relative, they're in the United States, they have a current visa or even an expired visa, they might be able to do adjustment of status. If they are a permanent in one of the F2B categories or one of the other categories, they're not an immediate relative, then but they're in the United States and they have a valid visa, they may not be able to adjust. They may still be put on the waiting list based on the visa bulletin. So we have had cases where people say, well, I'm a permanent resident, I'm applying for my spouse, they're here on a visitor visa, can we go to the next step of adjustment of status? No, unfortunately, you would have to apply for the I-130, get your priority date, and compare that priority date to the visa bulletin. So you can see, I'll just go back quickly to the visa bulletin for September 2024, and you can see that right now, people who applied or who in the F2A category, spouse of a permanent resident, the cutoff date is November 15, 2021. So that means that we're looking at least 2 or 3 years before being able to apply. However, this for adjustment of status. However, I should say that I'm showing the final action chart, which is the chart that determines when someone actually can get their green card. There is a dates for filing chart that is a little better. That does allow for filing of the adjustment of status application, although it cannot be approved until the final action chart says so. So right now for this category, it's pretty good. The government has said it's a June 2024 priority date eligibility or cutoff date. So that's moving along a little better. Okay. Just briefly, I just want to cover couple other things that you need to consider. If you're applying for a family member, or if you're a family member, you, as a U.S. citizen or permanent resident, you must complete an affidavit of support to show that you have sufficient income or assets in order to support your family member. Not necessarily that you are required to provide support, but your income will be considered once your family member immigrates to the U.S. as a permanent resident. Your income will be considered if they are ever trying to get any government benefits. They may be denied those benefits because of the fact that you have given an affidavit of support, or even in a case where you have if they have gotten benefits for some reason, they received benefits and the government determined that they should not have received those benefits, then they can actually look to the U.S. citizen sponsor or permanent resident sponsor to reimburse the government. So it is an obligation on the part of the U.S. citizen to provide the affidavit of support, and if required, to pay support in some cases. It rarely happens, but you should be aware of that. So just in the interest of time, I'm going to go quickly over some of the other things that you should be aware of if you're sponsoring a family member, and that is inadmissibility. So inadmissibility can apply to anyone who's applying for a green card, regardless of whether they're being sponsored by a family member or being sponsored by an employer. If you as the immigrant have a history, either an immigration history or a criminal record history that is serious enough, the government can deny your application for an immigrant visa. And so some of these things I've laid out here are the typical reasons why someone cannot get a green card even though they have a U.S. citizen sponsor. So if you're convicted of certain serious crimes, and this will be on a case-by-case basis, so even if you have had a conviction, it doesn't necessarily mean that you could not get a green card, but you would need to contact an immigration attorney to really determine whether that conviction is a bar or prohibits you from getting a green card. Other things would be misrepresentation or fraud in previous visa applications. So if you've ever received a visa or even applied but not received the visa, and the government determines that you misrepresented yourself when you applied, then that can also be a bar to you getting the green card. Unlawful presence, something we'll just talk about real quick in the next slide, that kind of applies to those in particular who came to the U.S. without a visa, like they crossed the border. It doesn't necessarily apply only to that circumstance, but unlawful presence can be a big issue for those, especially be a big issue for those who came into the U.S. without permanent status. I mean, without a visa. In previous removal or deportation, that can also make you inadmissible. And then if you have had if you had a J-1 visa at any time that was subject to the 2-year foreign residency requirement, you would need to meet the foreign residency requirement or get what we call a J-1 waiver before you can actually get a green card. And then other things that could be considered would be medical grounds. For example, it's very rare. It would really have to be something like a communicable disease that is not treatable or something like that before you would not be able to get a green card on that basis. But for every green card application, a medical exam is required, and that's the reason why, because they want to look at whether or not there's going to be any issue that could affect the public health of the United States. So finally, as far as family is concerned, and then we'll go on quickly to citizenship and then have time for questions. So as I mentioned, please be sure to ask your questions. If you have questions, go ahead and put them in the Q&A bubble area so we can be able to answer them. So the next immigration path I wanted to discuss is the parole in place. So this is the new, well, it's not necessarily new, but there is a new aspect of this program. Parole in place it's not a visa status or it's not a green card, but it does allow for people who have had or who've had immigration violations to potentially be able to stay in the United States, even if they're not eligible for a green card. So parole in place, generally, we call PIP, allows certain undocumented family members of the U.S. citizens to stay in the U.S. temporarily. Again, we're talking only about immediate relatives, people who are U.S. citizens, or people who are U.S. citizens wanting their family members to stay in the U.S. is primarily for spouses, children, and parents. There is on the second bullet point here, it talks about U.S. military members. So the military parole in place has been in place for years and years, and it was specifically for military members. But now there has been an expansion of that under the Biden administration as of actually this week, August 19, 2024. Certain people can apply for parole in place, and there are certain benefits to that, which I'll talk about in a minute. But it only applies, this new parole in place only applies to undocumented spouses and stepchildren of U.S. citizens. And what they mean by undocumented is those who enter the United States without a visa. If you enter the United States with a visa, and you're married to a US citizen, for example, you do not need parole in place because by law, you are still eligible to apply to get your green card in the United States, regardless. If you recall earlier, I talked about those who are immediate relatives, but they entered without legal status. They entered crossing the border. And as a result, even if they're married to a US citizen, they would not be able to apply for adjustment of status and remain in the United States to get their green card. Instead, the typical process for them is that their spouse would apply for the I-130, get that approved, then they have to agree to go to the US Embassy outside the US in order to get their immigrant visa. However, the danger in that is that because they have been undocumented, and in most cases they have been undocumented for more than a year and they have unlawful presence, if they leave the United States, even if it's to correct their status, they will be told they cannot return for 10 years or more. And in that case, it's not something most people want to do, to present themselves, leave the country, and not be able to return. So currently, there is a process called a I-601A waiver process that does allow people to get a waiver of that 10-year unlawful presence bar, meaning that if the waiver is approved, they can go to the US Embassy and they will be processed as normal and be allowed to return immediately. However, in some cases, the waiver is just not possible. So in that case, the government has offered another option, which is the parole in place that I mentioned. And this again is for spouse of a US citizen who was married to the US citizen as of June 17, 2024. So the marriage had to occur before June 17, 2024, on or before June 17, 2024. It can also apply to stepchildren of a US citizen. So stepchildren of a US citizen are usually qualified as immediate relatives if they were, if the parents were married before age 18. So this does not apply to any stepchild. It applies to only those stepchildren whose parent was married before age 18, where the parent and the step-parent were married before age 18. The stepchild is unmarried at that time. And also if the stepchild is under the age of 21 as of June 17, 2024. So what does that mean? Well, another requirement is that they must have continuous residence in the United States. For spouses, those who are qualifying as a spouse of a US citizen, they must have been present in the United States for 10 years, at least 10 years before June 17, 2024. So they must have been in the United States at least since June 17, 2014. They couldn't have been here earlier than that, but if they were not here, if they entered the US in June 2015, they would not qualify because they do not have that 10-year minimum. For stepchildren, they just need to show that they've been in the United States since June 17, 2024, up until the time of filing the parole in place. And another important thing is there can be no serious criminal record, nor can there be any serious immigration record. It's very specific, but some immigration records, such as deportation and re-entry after deportation, things like that, could be a bar to this as well. So they could not be eligible for parole in place. Everything is on a case-by-case basis, though. So before determining whether or not you qualify, you should definitely speak with an immigration attorney to be sure whether you are eligible or not eligible. So what are the benefits to parole in place? As it says, the point of it is to keep families together. And how it does that is that for those people who are undocumented, it provides a temporary protection from deportation. So as long as they have parole in place, they are not going to go into deportation proceedings. They're eligible for work authorization. So that means they will have a valid work authorization card to work anywhere. And for many, it would also allow them now, instead of having to get a I-601 waiver, I-601A waiver and leave the United States, they can now apply for adjustment of status as if though they were legally in the United States in that sense. So this is an important benefit. My understanding is that it could affect about 500,000 families. So if you know of anyone who's in that situation, or if you think that you might qualify, please reach out to us and we can determine if you are eligible. So next I'm going to talk about how to become a U.S. citizen. We'll go pretty quickly through that. So if you are a permanent resident and you want to naturalize, become a citizen, you must be at least 18 years old to apply. You must be a permanent resident, a lawful permanent resident for at least 5 years. But if you were married to a citizen, U.S. citizen, and during for 3 years, no matter how you received your green card, if you have been married to a U.S. citizen for 3 years and that U.S. citizen has been a U.S. citizen for those 3 years, then you can apply for citizenship. Also very important is that you must have continuous residence. So you must be able to show that the U.S. was considered your permanent resident. You did not leave the United States for long periods of time. One example would be so that would mean, for example, you need to have actually be physically present cumulatively. So you would just add up the time over the past 5 years or over the past 3 years. If you were spouse of a U.S. citizen, you would add up the fact that you have been physically in the United States for 18 months or 36 months if you're going on the 5-year qualification. So you have to show basically that during your qualifying period, 3 years or 5 years, that you have physically been present for at least half that time. Also, if you have had trips outside the United States that have lasted for more than 6 months, then you may have been considered to break your continuous residence. Doesn't automatically mean that you could not qualify for citizenship, but if that has happened, you will need to show that you never intended to give up your permanent residence, or you intended to be, you still intended to be a permanent resident, that the trip was still very temporary, and that your residence was actually the United States. So you would need to provide proof of having a home here, for example, having finances here, filed your taxes, did everything like anyone who's a resident would do, but just that your trip lasted a little bit longer than 6 months. If you have a break if you stayed out of the U.S. for a year and did not return, then you automatically break your continuous residence. You also now have to wait another 4.5 years to apply for citizenship when you return. So if you are in the 5-year period or the 3-year period, I urge you to file immediately for citizenship once you're eligible, and not wait, because if you do and then you end up having to have a trip somewhere or having to do something outside the U.S., maybe even go for work or something like that, where it's going to be a long time that you're at the U.S., you may end up taking a lot longer to become a citizen. Another requirement for citizenship is having good moral character. So they're going to look back 3 years or 5 years, again, depending on your qualification, to see if you have any kind of criminal history, any other issues, which we'll talk about just now. I'll talk about in a minute, that would be considered lacking in good moral character. But before we talk about that, I do want to talk about the English testing. So there's always an English testing and a government testing requirement. So first of all, you must speak, read, or write English unless you're exempt. And the exemptions are very, very specific. It's age related and related to how many years you have actually been a permanent resident. And so as you can see, I don't have time to go through each one of these, but there's different requirements for you to be exempt from the English test. There is another exemption if you have a physical or developmental disability or mental impairments that have been lasting more than a year. Then you may be able to be exempt from the English testing and even the government testing, if civics testing, if you if a qualified U.S. physician or a clinical psychologist can verify through the N4648 form that you are not able to take the testing or learn English or learn the government testing, the government questions. So coming to the government questions, there is a U.S. history and civics test. Again, unless you're exempt from that, you will have to take that. It is usually a verbal test of about 10 questions at your citizenship interview. As long as you answer 6 out of the 10, you will pass the test. And there are plenty of study guides on the USCIS website to help you prepare for that. Once you have passed the test and your citizenship interview, then you get the oath of allegiance and become a citizen at that point. And then it's definitely recommended that you apply for a US passport, because you will no longer be able to use your green card for any purpose, especially not for travel. So what are some ways that you should, or what are some reasons why you should not apply for citizenship? So if you have had a permanent bar, meaning that you have been convicted of these very serious crimes, while you're a permanent resident, then you're going to be banned forever from becoming a citizen, if your green card in itself is not revoked or canceled. There are some other temporary bars that if you have committed any of these kinds of actions or crimes, that you may have to wait until it's been 5 years since those crimes have been committed or those convictions have taken place. So you want to make sure that, for example, if you have a shoplifting charge that you were convicted of or agreed to, then you already have, and that charge or that conviction occurred last year, and next year you're eligible for citizenship because you have 5 years of being a permanent resident. You probably will not be approved for citizenship. You will need to wait 5 years from the date of the conviction before applying again. Some other bars to that could be, these are discretionary, so it's up to the immigration officer. They can deny your citizenship application because you haven't paid child support. Extramarital affairs can be considered. If you fail to register for selective service, or you fail to pay taxes and you have outstanding tax violations, those things can be reasons to deny your citizenship application. So if you have things like that, you want to make sure you clear those up before applying. And the risk of applying, as I mentioned, if you have had those issues, then you may, those issues that I just mentioned, you might not want to take the risk in some cases of applying for naturalization, because that will now have the government reconsidering or looking at your immigration record more closely. And so it could end up that if the issue is strong enough, I guess, if the issue is a revocable bar, then you may actually even lose your permanent residence. You may be placed in deportation. So just denial of your citizenship application could be the least of the issues. It could be other things. You can even be subject to criminal prosecution. So you want to make sure you have a clean immigration history, a clean criminal or no criminal record, or at least cleaned up a criminal or had a criminal record that's not that serious in order to apply. The other consideration is totally up to each individual to determine whether they lose their home country citizenship if they apply. I want to make clear the USDS does not require anyone to give up their home country citizenship to become a US citizen. It's not required at all, but what determines whether you lose your home country citizenship depends on your home country. So you want to find out from your embassy or from a lawyer in your country whether or not you would lose citizenship if you became a US citizen. So I'll just skip over that and just talk briefly about procedure. So processing right now is pretty quick for citizenship applications. It's probably the fastest that we've seen in years. The government has really made an effort to make these applications a priority and to approve them as quickly as possible. So you definitely want to apply at your earliest eligibility, in which case, if you have been a permanent resident for 33 months and you've been married to a US citizen during that entire time, you can apply. If you've been a permanent resident, otherwise you would have to wait in the 57th month of your green card anniversary to apply. You just want to submit your green card and copy of all your passports, especially any pages that were stamped, so that they can verify your travel in the US. You want to have a check for $760 for your filing fee. That's if you file by paper. They do have an online process, which I think saves you $30 if you apply online. and it gives you a quicker response, at least in terms of getting your receipt notice and your biometrics notice. And after that, after you apply, you should expect an interview within 3 or 4 months. And then after the interview, sometimes on the same day of the interview, but usually within a month or two after the interview, or a few weeks even, you will get your certificate of naturalization. Okay, so now I'll go to question and answer. I do see a few questions here. But before that, I want again to remind you that this information is very general again, and it's not for your specific situation. If you have questions about your case or your eligibility, please do reach out to us and schedule a consultation so that we can go over your background and answer your questions thoroughly. So first question I have, which has two votes here, is so it's okay to be illegal, came in legally, but have overstayed the visa and then apply to adjust status. Does that jeopardize the application in any way? Well, it's quote unquote okay. I mean, certainly if you are here illegally, whether in the case where you came in legally but you overstayed your visa, you are still deportable. Meaning that if the government decides they want to start the deportation process, they can. However, they will not do that if you are married to a citizen, or you're a parent of a U.S. citizen, or you're a child under the age of 21 to a U.S. citizen, and you have applied for adjustment of status. So yes, you in those immediate relative categories only. It does not apply to other categories that we discussed, only for the immediate relative categories. That individual who overstayed their visa can apply for adjustment of status. That the fact that they overstayed does not jeopardize their adjustment of status application, because by law they are permitted, and that is sort of, they are permitted to apply for adjustment of status because they are an immediate relative. And so that overstay is pretty much forgiven. In that case, even if there was unauthorized employment, that is also forgiven as well. So yes, it does apply. That is a circumstance for those who are immediate relatives who came in with a valid visa and overstayed. Okay. Next question is, after getting green card following 3 years of a J1 visa, can you apply for citizenship directly, or do you need 5 more years of stay in the US for citizenship? So once you receive the green card, then from the time you receive the green card, you have to be in the United States, or you have to have had the green card for 5 years before you can apply. So if I think I understand your question, you're asking if you've had J1 visa for 5 years and now you got your green card today, can you apply for citizenship? And the answer to that is no. The 5-year requirement applies to after you receive your green card. So you have to be a permanent resident for 5 years, not a different visa type for 5 years. Okay, next question is, can there be adjustment of status for a brother of U.S. citizen born in India, but currently a Canadian citizen and a TN visa holder? So that depends, but yes, if they are in the U.S. as in a valid visa status, and they are maintaining their valid visa status, and the priority date is eligible for adjustment of status, then yes, they can adjust status. So the key to that is the priority date, right? Because as I mentioned before, and I'll go back to the slide of the priority dates. If you, oh my goodness, it's so far back. Okay, so the priority date is what you have to look at to determine whether someone can apply for adjustment of status. And so if the brother would be in the F4 category, born in India, which will be the date showing there is January 22nd, 2006 is the cutoff date. So if you applied, or if you were applied for before January 22nd, 2006, and you're in the United States as a TN visa holder, then yes, you can apply for adjustment of status. Okay. If there's any more questions before we close, I'd be happy to answer. We have a few more minutes. I will check once again in the chat. So there is a few questions that are in the chat and not in the Q&A, but I'll go ahead and answer those. But to remind you, if you do have a question, please put that in the question and answer section of your platform there. So one question is, does the criminal record of U.S. sponsor affect green card application? So in most cases, it does not. However, there is one case, one crime, and it's usually a sexual predator type of crime, underage. I don't even want to talk about it, but basically it's if they have a criminal record where they're on this listed as a sexual predator, then that might be an issue. It depends on the type of application, but the type of relative. So for example, if it's for a spouse, it's more serious, or for a child, it's more serious. If it's for a parent, it may not be considered as much. But it's on a case-by-case basis. So if there is a criminal record of a U.S. sponsor, definitely want to look into it deeply to determine if it will affect a green card application. Another question is, can I convert my visiting visa to a student visa and my family will be my dependents? So, well, certainly you can if you're eligible, and you can apply to change from visitor to student visa. And usually family members who are children under the age of 21 and spouse are able to become dependents on your student visa. So student visa is usually the F1 visa. Family members get an F2 visa. So it's possible, just depends on whether you're qualified for that. And then another question is, can a citizen apply for a sibling who is married with kids? Yes, definitely. Actually, then that's a good question, because if you apply for a sibling, that's the F4 category, then it also includes their family members, meaning their spouse and children under the age of 21. So yes, you definitely will be there. They will be included. It's not a separate application. You apply for the sibling, and then and include the names of the family members in the application, so that when in 10, 12 years, which is a long way off, but at that time, those family members will be included as part of the application for the sibling to immigrate to the U.S. I have one more question, and it is related to the green card. However, the question is about changing from O1 to a green card application. I do suggest that you reach out and schedule a call about that. This form is mainly for family-related green card applications. So certainly you can change from a visa type to a green card based on family if you have one of the relatives, spouse, U.S. citizen spouse, permanent resident, or parent who can apply for you, or sibling. Okay, I think that's all the questions today. I want to again thank everyone for attending. If you enjoyed our seminar, please feel free to share a Google review. You can Google Badness and Associates and find our Google review, Google review website or platform and post a review about the webinar, or you can use this link as well. I would very much appreciate it. It will help others to join us for webinars that could be helpful to them. If you do need more information and advice about your specific case, please feel free to contact me at any of these things at Ann Badness at Badness Law, or ideally go onto our website and fill out our contact form, or call our office as well. So again, thank you so much for attending the webinar. We hope this was informative for you, and we wish you all a great day. Thank you.